Hello and welcome to the ANU International Law Society Career Series, Unravelling International Law. We acknowledge the Ngunnawal and Ngambri peoples, traditional custodians in the land on which this interview was recorded. We pay our respect to elders past, present and emerging, as well as any Aboriginal and Torres Strait Islander viewers. We hope you enjoy episode 7.
My name is Angelique Nellis and I'm the Careers Director of the ANU International Law Society. We are truly fortunate to have a remarkable individual join us from Sydney for our 7th episode of our video series. He is renowned for the significant legal, political and social reform contributions he has made, most notably through his role as the Australian Human Rights Commissioner, in which he was praised for being a powerful advocate for the institutional voice. With his 5-year term recently finishing, he is said to have left a significant and enduring legacy. It is in this capacity and his other notable achievements that he joins us today. Without further ado, I would like to welcome the remarkable Mr. Edward Santow. Mr. Santow, on behalf of the ANU International Law Society, I would like to thank you for taking the time to join us this morning. It is a privilege to have you on our video series.
Oh, it's great to be with you all.
So firstly, prior to your many impressive achievements, including being the recipient of the Australian Leadership Award and Youth Global Leader, you were a law student like myself and many other viewers here today. With many of us, trying to navigate balancing law school and the continuous quest for, gaining that practical experience, there was one story of yours that really stood out to me. I believe it occurred when you were 20 years old and you had just finished 2nd year of law and you were interning at the Public Interest Advocacy Centre, and you noted that the client, Scarlet Penny, was the case that truly changed you. And I was just wondering, for myself and the viewers, would you be able to elaborate on why this case really stood out to you? And maybe secondly, what advice would you give to students who want to continue to gain similar practical experiences?
Yeah, I mean, it doesn't feel like that long ago that I was a law student, but the kind of grey hair that I'm sporting these days suggests maybe it's a bit longer than I like to admit. I think one of the things about being at law school is that the law sometimes sort of seems confined to words on a dusty page or on a computer screen. And I think one of the things that can kind of bring the law alive is to seek out opportunities to, start to get involved. And that could be at any level. And you're right, I was interning at the Public Interest Advocacy Centre. And I happened to have the good fortune to be doing very, very minor work, I hasten to say, on a really important test case. And the client was Scarlet Penny, and she's an amazing girl. She was she had these big curly locks. She would have been about 10 or 11 years old from memory, and her parents wanted to send her to a private school, a school called the Hills Grammar School. And it just so happens that as well as being incredibly articulate, funny, creative, all of those good things, she happened also to have spina bifida, which is a condition that didn't have any impact on her intellect or anything like that, but did have an impact on the way she moved. The school, however, decided not to honour her place and decided to withdraw her place. So this was one of the really important test cases still in the fairly early days of the Disability Discrimination Act. And it was really challenging that prejudice that the school had about what kids with disability could do. And I guess for me, it was so important because you can look at that concept, all people should be treated equally regardless of things like their disability. And of course we can sign up to that makes perfect sense. But until you kind of lock eyes with someone who has experienced the opposite of that, who has experienced unfairness, indeed discrimination, because of something they can't control, like their disability or their sex or their age or their race, then it's hard to, I guess, move from your left brain, which is the more kind of intellectual, rational brain, into your right brain, which is the more emotional side. And this was the sort of case that allowed me to do just that. It made me really sense that this stuff matters, and it doesn't just matter in an abstract sense, it matters in a real sense. So having that sort of opportunity whenever you can find it, I think is really useful in understanding what the law truly means.
And thank you so much for sharing that. And I believe that fits really well in a statement that you made earlier about how lawyers need to go beyond, those bookshelves or the computers that we deal with now, but actually get into that practical work and address, those social issues that are prevalent and are very existent in our society. So I think that definitely will help a lot of our law students listening in today. And I think continuing from that, you've really had a history of engaging with those social issues, not only domestically, but internationally. And I was quite interested in your roles previously, both as a research director at Gilbert and Tobin Centre of Public Law, but also I noted that you were involved in the Global Alliance for Justice Education, and I was quite interested. In 2001, you attended a conference in South Africa analysing HIV and the AIDS crisis, but from a legal perspective. So from all of those experiences, both domestically and overseas, I was wondering how you felt that engaging with international law, whether that is, with those global issues, whether they, have an impact in how we as Australians are informed about dealing with social problems within the domestic sphere.
Yeah, so that experience that I had with the Global Alliance for Justice Education was when I was still a law student, and I had an amazing kind of academic who kind of took me under his wing a bit. His name is Professor Les McCrimmon. He's now based up in Darwin, and he said, look, you need more practical experience. You spend, a bit of time in the library. That's fine. That's good. You'll benefit from that. But you need to get out there. And at that particular moment in time, HIV and AIDS was just kind of absolutely ravaging sub-Saharan Africa. And I'm not suggesting that problem has gone away, but it's less serious now than it was at the time. And I had this opportunity to go to South Africa to learn a bit more about what was happening. And there was a really important international law as well as a domestic law issue there. And that was this. There are drugs that are not a cure for HIV and AIDS, but that can allow people to live with HIV and AIDS, and can also inhibit transmission of HIV from the mother to the child. There's a drug that's been around for a very long time called nevarapine, which only costs a few dollars, that can stop or can make it much less likely that HIV will be transmitted from a mother when she's giving birth or when she's breastfeeding. It's only a few dollars, but for many people in those sub-Saharan African countries, including in South Africa, they just simply couldn't afford it. And you had this situation where pharmaceutical companies who had patented these drugs were saying, we're not going to give a discount. We're not going to give it, and we're certainly not going to give it for free. And so what I had the opportunity to do was work with, again, at a very low level, some people who were doing really important groundbreaking work to say, under international law, there's a treaty called the TRIPS agreement, which deals with intellectual property and patent law. There are exceptions for when a patented medical drug should be made available in an emergency and made available at a much reduced cost or no cost at all. And so they were doing groundbreaking work, but again, being able to see that on the ground and see what that work looked like, but also what individuals who were experiencing a denial of justice, what their lives were like, that was, I think, vitally important for me. Now, of course, we're in the midst of a pandemic now, so that work has a new resonance, and we can see a real inequality in the way in which rich countries like Australia and the United Kingdom and the US are in a sense receiving a disproportionate amount of the vaccine or the vaccines, whereas poorer countries often are not. And that's something that I think we need to address yet again.
No, that's very thought-provoking, and I think you're right. As you know, we transcend. There are key issues that need to be addressed, and there's those themes that keep appearing that need to have a solid solution to that. So thank you very much for your insight on that. And now I thought it may be good to delve into your time as the Australian Human Rights Commissioner, as we've touched upon. So during your time, you were really praised for putting human rights at the core of your work. From your remarks in 2016, when you foreshadowed that international law should and is required to involve marriage equality, to later on your examination on how ratifying a treaty on torture could improve the rights of detainees, you have really had a commendable insight into how international law and domestic law can be intertwined with human rights. So having said that, how have you seen international law engage with informing how the AHRC proceeds with human rights matters? And are there any examples that stand out for you during your time?
Yeah, I mean, it was such an honour to be the Human Rights Commissioner. It's not something I ever really even dreamed of. And now, a month after I finished, it feels a little bit like maybe that was all a dream. It's a wonderful role. It was a big responsibility, and I took that responsibility very seriously. In a sense, international law is actually really important to how I wanted to fulfil the role. I didn't see the role as one where I was essentially a government-funded activist where I had a chance to just express all of my views with the megaphone you get as Human Rights Commissioner. I saw it differently. I saw it as a very important chance to try and make international human rights law real for Australians. In other words, apply international human rights law and Australian human rights law to some of the most difficult issues, social issues that we face. And so the examples you gave are really important ones. So with marriage equality, the law develops over time. And there was an emerging new consensus that to exclude people who were in kind of non-heterosexual relationships from being able to engage in civil, as distinct from religious marriage, was inconsistent with the International Covenant on Civil and Political Rights, specifically the equality or non-discrimination provisions there. And I think that's true. I don't think it was an absolutely clear-cut argument, but it was certainly, I think, the better view under international law was exactly that. So Australia needed to recognise that. And we certainly weren't the kind of earliest adopter. There were several jurisdictions that moved to legalise marriage equality before we did. But I do think it was important. And I think it was important to do it in a way that respected the nuance. So I've emphasised a moment ago, it's civil marriage that is enabled by marriage equality legislation here in Australia. So each individual religious organisation can choose whether or not they wish to solemnise the marriage of, say, two men or two women. And so that strikes a balance, which I think is reflected in international human rights law. The other example you gave is also really important. I'm so proud to have been a part of that one too. So the optional protocol to the Convention Against Torture is a treaty that is not particularly well known. It's a treaty in its own right. And essentially, it came from this really interesting realization a bit over a decade ago. And that was that we have in the kind of core treaty, which is the Convention Against Torture, a range of rules that really clearly set out, starting with torture, how you need to protect people's human rights when they are detained. That most obviously could be in a prison or an immigration detention facility, but even in mental health facilities, aged care facilities, and so on. So it basically sets out, here are the things you must not do, and here are the things that you must do in order to maintain the dignity of people who are deprived of their liberty, in other words, are detained. So those rules are really clear. Nevertheless, there were still serious problems throughout the world in how people are detained, in maintaining human rights in places of detention. So this new treaty, the optional protocol to the Convention Against Torture, was developed as a practical way to make sure those basic rights in the Convention Against Torture could be realised. And it was really about inspections, making sure that you have independent inspections in all places of detention to identify problems before they become just completely catastrophic. So in a sense, you know, we talk sometimes, and you know, I'm sure many of the students will recall 5 years ago, the horror from Four Corners when it showed the Dondale Youth Detention Centre and use of spit hoods and all kinds of coercive action against young people who are detained there. What we want to do is avoid that problem, avoid that situation, and instead have inspectors go in and identify problematic practices and address them at their, you know, at the root. And so what we did at the Commission is we worked really closely with the government to help the federal government and the states see the value of this treaty, and in turn, they ended up ratifying it. And then I did a really big project, which was essentially, how do we implement this treaty as effectively as possible? Because every good international law student will know that international law tends to set out high principles. And so it leaves a significant degree of discretion or margin of appreciation for individual countries in determining how they actually implement it. So that was a really big piece of work. We're not there yet. But we have made, I think, important progress along the way to having that be implemented really well.
Fantastic. And I think you're right that progress, it's definitely from 5 years ago, significant changes have been made. And I know even your commentary this year has continued during the pandemic that we're currently facing. And I noticed during this year, you called on the federal government to enforce, you know, new safety measures within the immigration detention system. And I was wondering, with constantly evolving matters, based on your experience, what do you believe are maybe in the coming years the most pressing Australian human rights issues that we may see, or during your time there, and how do you see international law assisting in addressing that?
Yeah, I mean, there's almost two categories. There are the kind of long-standing problems that we as a country and sometimes as a world, we haven't yet been able to address effectively. So in Australia, two of the most obvious ones are the injustice that our First Nations people have experienced ever since colonisation, and the kind of reverberations continue to this day. I mean, I mentioned youth detention in the Northern Territory. On any given night, fully over 95% of young people who are detained are Aboriginal or Torres Strait Islanders. Just think about that, over 95%. Sometimes, some nights it's 100% of young people who are locked up in the Northern Territory are Indigenous. less than 3% of the Australian population is Indigenous. And that's an extraordinary statistic. We must do better. And the Commission has a really important role in kind of working persistently and creatively to address those long-standing problems. Another really obvious one is refugees and asylum seekers. In many respects, Australia does things that no other country does, and not in a good way. The average period that someone will be detained in an immigration detention facility in Australia is well over 600 days at the moment. Just think about that. That's the average. In countries that we would compare ourselves to, like the UK, Canada, it's less than 20 days. In the UK, it's usually around 30 days. In the US, even under President Trump, it was around 30 days. We're over 600 days, not because someone's committed a crime, but simply for what's known as administrative detention. We must do better than that. And so, yeah, they're really important kind of long-standing projects like that, or issues like that need to be addressed. And then there's a second category. So climate change, I think, is one where the human rights community and the international community need to do better. And it's going to be, the defining issue of our time, whether we're able to address that. And it kind of, I'm sure, keeps many of you up awake at night. It certainly does me. We must be focused on that. And then for me personally, I've had a big focus on the use of artificial intelligence and how our law can more effectively respond to make sure that AI gives us the future we want and need, and not one that we fear.
Fantastic. I think that flows really well into my my next question for you. And as I mentioned earlier, at the beginning of this month, you commenced a new position. So congratulations on being appointed Industry Professor Responsible Technology at UTS. And I note that, as you mentioned just then about AI, that you want to use this platform amongst other aspects to promote ethical development in AI. And I was just wondering, having previously led many influential projects worldwide on human rights and social implications, what role do you see international law playing in the ever-expanding area of AI, and how do you see them interacting?
Yeah, so, AI is kind of, the hot new technology. It's kind of being integrated into pretty much every aspect of human activity, and it crosses boundaries, and that last point is really significant. So a piece of technology that is developed in the United States or China or some other country can then be deployed in Australia, but it's often more complex even than that. There may be elements of the technology that are developed in one country, smooshed together with other elements developed in other countries and then deployed in a third country. And so international law clearly has an important role to play where you have that trans-border element. And we also know that the impact of AI on us, on people, can be truly profound. And so it's very important that the existing protections, especially set out in international human rights law, are adhered to as we kind of enter what's become known as the fourth industrial revolution, to make sure that people's basic rights are protected as the way in which we work, make decisions, experience the world are all changing so profoundly.
Yeah, and I think you're very accurate when you say that there's a lot of international influences with that. I know I recently did an article, some research on Davos and how that's being influenced, and how that started in the US and other areas, and is now kind of seeing trickle down in Australia with the recent federal court ruling. So definitely a very interesting space, and I wish you the best of luck as you continue to delve into that in your new position. And I think to conclude, one final question is maybe just some advice to our law students. So it was quite refreshing to hear in an interview that you stated that whilst you didn't have a clear career trajectory in mind, you knew what you were interested in, and you had a clear sense on, you know, creating laws and policies that ensure that Australia's basic rights are fairly treated. And so with this, I think that's a good reflection on how maybe a lot of law students may be feeling, that they're, you know, interested in certain areas, but they may not have a pre-established pathway. So I was wondering, is there any advice that you would like to give to students who may be in a similar position?
Yeah, I mean, a couple of things. The first thing is there's more than one pathway. So don't feel, you know, if you're still kind of trying to find your way, that's unusual, and it's certainly not a problem. I think that takes a long time. And I had this general sense that I wanted to help people with my law degree. It wasn't a lot more sophisticated than that. And so I tried lots of different things that would be, you know, potential ways of doing just that. And each of those things was important experience for me. But I wasn't one of those kinds of people who I admire, but I'm just not that kind of person who had this really clear sort of 5 or 10 year plan. Go, I'm going to do this and that'll. That's very impressive, but it can also be a bit limiting as well, because you know, Robert Frost said, you know, way leads on to way, and it's true that if you kind of really live in the moment and try and make the most of what you're currently doing, then that can actually lead to something good next. But if you're kind of so focused on what the next step or 2 steps are, then it can kind of take your focus away. So that's one thing. The second thing was a piece of advice that I got when I was working on Scarlet Penny's case as an intern at the Public Interest Advocacy Centre from the then CEO, an amazing woman, Professor Andrea Durbach. And I remember asking her as a student, you know, how do I get into this whole human rights law thing? And she said, you know what the most important thing is? If you want to be a good human rights lawyer, be a good lawyer. Get your technical skills right. It's not, frankly, enough, and it's not even that kind of helpful to say, I'm passionate about human rights. I'm passionate about helping people. That of course, that's true, right? Like that, people with those feelings, of course, they're going to be drawn to human rights law. That doesn't differentiate you at all. Surely you want to win cases for your clients. Surely you want to have a positive contribution. And just being kind of passionate about something isn't going to get you there. You want to be really rigorous. You want to be someone who is a formidable opponent for someone on the other side who may be, you know, representing, you know, the person who is allegedly the human rights violator. So that was really important advice, and it seemed so obvious. It didn't feel that at the time. I suddenly thought, oh my gosh, I really need to kind of, you know, really focus in on this. And to be honest, that didn't mean that I focused kind of consistently across all of my subjects. There were some subjects where I kind of felt, you know what, I don't think I'm ever going to be a corporate lawyer. This matters less to me than things like international law and administrative law and so on, and public law, which are so much more important for people interested in human rights. But that was, I think, really, really useful advice. And I think it means that what you're doing at law school matters, right? It's not that you're just kind of, you know, waiting out the clock until you can start living your life. What you're learning, that the content, but especially the skills and the way of looking at problems, those things are super useful, and they are formed for most people when they're at law school. So I think, you know, sort of enjoying that, appreciating, finding value and meaning in the work that you're doing now is really important. And I genuinely do hope you enjoy it. And it's been a great honor and a pleasure to speak with you.
No, thank you. And I think to conclude, there was a statement that you stated that your mum made, in that you should pursue things that benefit others, and, you know, you should work towards filling your work life with something that has true meaning, and not just chasing, you know, monetary or other benefits. So I think that's a very holistic approach that all law students should definitely keep in mind as they proceed forward. So with that, that brings us to the conclusion of our interview. Once again, thank you so much for joining us. I know myself and other law students have definitely found this very informative, and I look forward to seeing all your continued brilliance continue at UTS. But thank you once again for joining us.
It's an absolute pleasure.